I'd like to just in a very general way discuss medical legal aspects of breast imaging. And medical malpractice has quite a long history, 4,000 years. In the Code of Hammurabi, a physician was accountable if that physician made a large incision with the operating knife and killed the patient, or opened a tumor and cut out the eye. His hands will be cut off, certainly much worse consequence than now. Also, if the physician perform a serious operation on the ass or the ox and kill it, he shall pay the owner 1/4 of its value. So we see right here that damages were also instituted way back when. The Jewish Talmud also held physicians responsible and liable if they intentionally harmed the patient and thus needed to make restitution for these damages. And it was interesting that those physicians that were licensed by the community or within the society, even if they did make a mistake, were exonerated from blame. And the modern theory of medical liability originates actually in the British and United States common law. A renowned legal scholar, a British legal scholar, Sir William Blackstone, described in his commentaries on the laws of England that neglect or unskilled management of a physician or surgeon is malpractice, and that is the etymology of the current word malpractice. It's Latin meaning poor practice or bad practice. In a case, Slater versus Baker and Stapleton in 1769, the British courts ruled that a physician could only be found liable, however, if another physician, or what we now call the expert witness, decides that his conduct violated a certain standard of care. And interestingly, that physician really had to be within the defendant's locality or city in order to testify against them, because we know that standard of care can vary slightly from one community to the next. And in the United States, the first recorded malpractice litigation occurred in 1794, and that's actually just a mere 15 years after the signing of the Declaration of Independence. So it didn't take very long. And by the mid-19th century, state courts routinely held standard of care related cases. And in the 1830s, the first plaintiff recovered damages in a childbirth case for the careless or want of diligence and skill by the physician. Throughout the 20th century, the United States state courts developed what's called the judicial or common law on medical malpractice, and for a long time consistently followed these earlier decisions by the courts on medical standard of care. And in 1905, by this time, 39 of the 45 states enacted statutes requiring specific state licensing of physicians. And Texas was leading the trail, I should say, on being the first state to require their doctors and to have a state license. And with apologies to any attorneys in the audience, I would just like to go through a very basic discussion of what the legal system has, the type of cases that are heard by the legal system. And there's two basic types. The criminal cases where there is intent to harm, and there's harm to the society or to the community. And these are tried by the state prosecutor against a perpetrator. And in these cases, the proof must be beyond any reasonable doubt. And in civil cases, the word is used as in a civilized community or a civilized society where really no harm is intended by the perpetrator. It's a dispute between neighbors, who's more likely to be right, and the proof for these cases really is by the preponderance of the credible evidence. And medical malpractice cases are resolved as civil cases and specifically tried under what is called the law of negligence. And other examples of civil cases are contract law, property law, real estate law, driving or vehicular disputes also are tried under civil cases. And the civil law in this country is based on standards established by two sources. And one of the sources is the statutory law, and the second source is common law. And any departure from these laws is a tort, and medical malpractice is considered a tort of primary negligence or carelessness. And it's defined as the departure from established standards of care perpetrated by one party upon another. And it's also known as a civil infraction. And statutory law is a cumulative piece of legislation either on a municipal level or a state level or a national level such as Congress that have legislation that has been successfully enacted into the law and into the legal books. And these statutory laws are enforced by regulatory agencies, and ultimately, such as the FDA would be an example. And ultimately, these laws are decided and arbitrated in the courts. And an example of a statutory law is a state license. And as I said, Texas was the first jurisdiction to adopt the contemporary state licensure. And common law is a body of law that is not specifically covered by statutes. This common law is inherited from the British common law system, and it's a decision of judges that the judges have made, and they establish prior rules of conduct for society, prior rules, the way people need to act if they want to live in a nice community. And it's based on the legal principle of stare decisis, which means let the decision stand, let the judge's decision stand. And the appellate courts will establish legal precedents that are followed within a jurisdiction for any kind of situations that have similar facts to the case. And specifically, medical malpractice, I said, was governed by the law of negligence. And the law of negligence is a very kind of a narrow legal idea within the law. And it's concerned with those individuals who profess to be competent in certain public callings. And a physician, a dentist, architects, engineers are all, if there's malpractice, they are also tried or assessed by this law of negligence. And it's failing to meet a standard of care. And negligence in any profession is really in the scope and course of the duty of that professional. And it's interesting that the law of negligence is also founded, and this is very important, on the standard of conduct of the professional rather than the actual consequence of the conduct. And that can get very confusing because usually it's the adverse outcome that triggers the lawsuit, but it really is the conduct of the professional, not the consequence, that has to be evaluated by the jury. And it's very difficult for the court at times to distinguish the two, and it's the physician's conduct that really is at issue. And the test for negligent conduct is a term called foreseeability. Is the physician's conduct the conduct has to be directly related to foreseeability. And an example would be, is it foreseeable? Is it that the abnormality on the mammogram represents a malignancy? Was that foreseeable? Was it foreseeable that the fax I sent, or that the letter I sent, or the email I sent did not reach the intended party? Was that foreseeable? And that really is the test of negligent conduct. If it was foreseeable and you didn't make that judgment correctly. And the one thing that the attorneys stress, malpractice, although it's very hard for physicians who've been involved, but malpractice cases are about like negligence and carelessness and not about incompetence. And the plaintiff does not need to prove that the physician was incompetent, just negligent. And there really has never been a claim that there's been intentional harm by the physician, which would then bring that into a criminal case. And I am sure that's probably very rare. I've read a couple case reports or a couple papers, and I really haven't seen any plaintiff bringing it before a criminal court. And the tort of negligence then has 4 elements, and I won't read this, but there's the establishment of the duty of the professional to the person. And in the case of the physician, it's the duty of the doctor as they relate to their patient. And if you take on the responsibility to take care of that patient, you then take on the liability. Then there's the breach of that duty is also the second element for the tort of negligence. There has to be the element of causation. In other words, the physician's conduct must be the cause in fact of the plaintiff's injury and has to have a proximate cause to the plaintiff's injury. And the final element of the tort of negligence that has to be fulfilled is the damages or the actual loss. And a lawsuit or a cause of action cannot really be filed if there's been no evidence for legal harm or if the damages are nominal. And proximate cause can sometimes be very difficult to prove, and that's why each side, the plaintiff's side and the defendant's side, get their expert witnesses. But the proximate cause states, for example, but for the malpractice, the patient would not have needed the mastectomy. There has to be a reason. But for the malpractice, the patient would not have needed chemotherapy or would not have had distant metastases. And that's, again, why the expert witnesses on both sides are called. And damages, of course, usually needs money. It means money. And the question that the jury will ask is, how would the patient have fared with what would be good standard medical care versus bad standard medical care? What harm could the patient have avoided? And what basically goes into the decision of what damages are. Oftentimes, of course, it's the income of the patient, future earning potential, the number of dependents, the age of the patient, and who decides. Well, it is the jury that will decide damages if it is brought before a court. And we are all entitled to a jury of our peers, and the Magna Carta entitled a fair trial and a fair jury, and it sort of originated with that the common man were frequently set up for judgment by the nobles, and of course one can just imagine what the outcome of that always was. So we are entitled to a jury of our peers, and for civil matters, there's a judge and a jury, and there are 6 juries who are given a set of facts, and each side at the time is allowed to eliminate 3 individuals, people that each side feels they cannot tolerate. And the jury is then instructed to establish the truth of the facts, and that occurs, the truth of the facts occurs with the cross-examination, and that is an attempt to educate the jury about what the issues are at hand. And they are asked then to apply the law of negligence to resolving the dispute. Who sets the standard of care? The standard of care actually is not set by the jury. It is the plaintiff and the defendant has to search again for the expert witness in educating the jury. Testimony is introduced, and this standard of care helps the judge and the jury establish what reasonable physician conduct would have been in those particular set of circumstances. And again, standard of care may vary by locality. It is the opinion respected by the minority rule. A standard of care is not something that has to be done by everybody. There's always felt to be more than one acceptable way to do things, to work things up, to follow things up. And the standard of care can be something new, it could be something old, even if only a few people follow this method. So it is not malpractice if there is a respected minority rule that is adhered to in the physician taking care of the patient. So breast cancer, as we all know, delay in diagnosis of breast cancer is a leading cause of lawsuits against physicians. And a study by the PIAA, which is a national consortium of physician-owned liability insurance carriers, conducted a study in 1995 and a follow-up subsequent study in 2002. And in 2002, the most frequent defendant was the radiologist or the mammographer. And the average settlement in 1995 versus 2002, as you can see, went up quite a bit, from $183,000 to $346,000. Why has this kind of proliferated? Why is this happening? Well, we certainly know that we have the opportunity to detect preclinical breast cancer. This is all evidence-based conclusion. And we know that this improves disease-free survival in certainly a large percentage of patients. But we need to remember really that the detection errors are not unique to breast imaging or to mammography in particular. It's just that the call for screening mammogram, the call for diagnostic mammography invites large volumes. So even if the percent of our detection error is not larger than anyone else, the sheer absolute number could be quite daunting, and the large volumes can invite a large number of lawsuits. The disputes are usually over issues of fact. The patient states she had a lump. A physician says that there was really nothing there. Subsequent records are really the only key to the facts of the case. So, as an attorney said, the usual scenario would be a young woman seen by a physician with a self-palpated mass. The mammogram was negative, and she was told to come back next year. And we all know that a negative mammogram in the context of a palpated mass certainly needs to be evaluated further. And here's just the graph, a summary of the malpractice claims from 1990, 1995, and 2002. One can see that the percentage of claims against the radiologist has increased from 11% in 1990, sort of reflecting our role actually in what we're doing, to 33% of claims filed against the radiologist in 2002. And the most frequent specialty that was named, again in 1990, the OBGYN, and when the consortium did their published study, 24% and 33% in 2002. Average age of the claimants also remained approximately the same in the mid-40s. And interestingly enough, the indemnity payment for those patients, the actual amount that the patient got went from the 58% to 43%. So the attorneys are making a little bit more money. Anyway, and the 2002, the breakdown of the 2002 study, the percent of the defendant, the radiologist 33%, the OBGYN 23%, and family practitioners, general practitioners, about 9%. And here we have the numbers that the average claim indemnity against the radiologist was approximately $350,000. And to settle a case versus a verdict versus mediation, you can see that mediation is actually overall the most expensive way to settle a alleged malpractice. Who is likely to sue? Again, in a conversation with a plaintiff's attorney, common wisdom suggests that it's those patients of decreased socioeconomic status, the poor, the Medicare, Medicaid, the uninsured. As we all know, especially here where we're working at Bellevue, they present with more advanced stage disease. But in fact, most of those patients are less aware of their legal rights, have less access to attorneys. So it turns out overall that it's actually the relatively more affluent who initiate most of the lawsuits. Again, as the graph or the chart demonstrated, younger women tend to be the usual plaintiff. About 69% of the plaintiffs are 50 years and younger. And why would that be? Also, the lawyers tend to like these cases because they're the quote-unquote bigger cases, bigger awards, and more worthwhile for the attorneys. What is the motivation for initiating a lawsuit? Well, a lot of people are angry, perhaps a need for money, encouragement from family and friends, the radio, if you've been harmed, call so-and-so. And also public perception and misperceptions, such as that mammography is nearly perfect. And as we saw earlier, we know that it certainly is not a perfect study. Also the idea that if you find breast cancer early, that you're completely cured. And if you wait 1 or 2 months, that you've developed a high risk of dying from the disease. So public education is very important as well. Mammograms also will be misread, the false negative mammogram, the lack of detection from many different causes, poor technique, poor quality. What constitutes a clear miss? Just blowing by something that you should not have missed. And of course, the impact of the retrospectoscope. The jury will look at last year's film, and if they feel that they can see the abnormality on the prior year, they feel that perhaps you should have seen it in the prior year. That only adds to the whole idea that the behavior was negligent. And the ambiguous language in reports can sometimes be very confusing. Really, you need to be as clear as possible. The BIRAD's categorization has helped to some extent with having more uniform reports and recommendations. If you're not sure about the diagnosis, you really need to do something else, follow-up, spot compression view. And interestingly, there has never actually been a case brought before the courts for overreading a mammogram, which the greatest harm would be a small biopsy. And as the attorney said to me, that's no big deal. There's not a whole lot of damages to just doing a small biopsy. So that was very interesting about the overreading. So poor technical quality, you really need to be sure your clinical images are done properly. If they will certainly latch on to a poor quality image, you missed the cancer because you were not watching out for your quality. This just, again, adds to the alleged negligent behavior. Failure to perform follow-up films is also an additional charge of negligence for the defendant. Unreasonable diagnostic evaluation, any kind of unreasonable impression would also constitute, again, a negligent behavior or negligent conduct. Failure to communicate the results, this is also very important. You need to be able to speak to the physician or to the referring physician and confer any information to that referring physician. Also, recovery of prior films is essential and considered in most localities a standard of care. Again, communication, not just for the mammographer, certainly across the board for radiologists, you really need to communicate any abnormal or unexpected findings. You need to have some kind of system in place where you document the patients that don't come back, either in a computer log or a paper trail or in a logbook, and you have to write this down. You have to have clear documentation that you've spoken to the patient and conveyed to the patient that this has been very important and that they need to return. If you happen to be the defendant in a case, recommendation again from the plaintiff's attorney with whom I've had a conversation, you're entitled to your own attorney. Don't take the first attorney that comes along, and it might not necessarily be in your best interest to have the hospital's insurance company attorney represent you, because as he was explaining to me, there might be a conflict of interest. That person wants to also satisfy the needs of the hospital, and maybe your needs and the hospital's needs aren't necessarily the same. And important, and it seems self-evident, but I guess doesn't always happen, if you are deposed, make sure you read the plaintiff's deposition first and have your films retain an expert to review your films before your deposition. Know what the expert has said and the opinion of the expert. How do plaintiff attorneys decide to take a case? Well, they claim they actually take only a very small percentage of cases that walk into the door. They don't want to get involved with difficult plaintiffs. Sometimes the juries really don't look very favorably on plaintiffs that are a little bit off maybe or overly aggressive. And perhaps all the cases they decide to take maybe 1% of cases that they're asked to take. They want to win. They certainly take cases that will increase their odds of success. And again, they really don't want to take cases where the outcomes could be very small. If they do decide to take a case, this will all start with a phone call to the plaintiff. They gather the records, get the literature that they need to look into the issues, and then, of course, they also send the case to their expert, and they would like to get a perspective from that expert. They want the unvarnished truth about what is going on. And one sometimes actually does question the quality of the expert. Don't alter your records. This happens more than one thinks. There are proper ways to make addendums and amendments on reports. Don't change the date. Don't retrospectively write anything into the chart. This would be, again, a further departure from the standard of care and can work very negatively to the jury. The jury, should it go to trial, really needs to see the physician as a kind, caring person, a thoughtful person. Don't be angry. Don't be bitter when and if you should be called to trial. They need to like you. And remember, and this is 65 to 80% of physicians that do actually go to trial win the case. But just to remember, the plaintiffs who do recover significant dollar amounts, the liability, the amount has gone up 110%. So even though physicians win probably around 2/3 of their cases, the indemnity payout has really increased. What is on the what could we do to look at medical liability reform? The American College of Radiology has created a task force on medical liability and radiology. It is trying to address issues such as physicians, I guess, struggling to retain and renew their medical malpractice. Premiums have really skyrocketed and put some physicians into early retirement or just quitting altogether. Insurance companies are for profit and they need to please their stockholders. So that is one issue that is being addressed. Hospital-based physicians now have to carry a higher level of coverage to obtain privileges in certain hospitals. All this leads to people in the United States worrying about medical access, restricted access, and all this is partly related, obviously, to the dramatically high jury awards that have been rewarded in some states. And it's forced, I guess, many residents and medical students to reevaluate what subspecialty they would like to pursue. And they've joined forces with the AMA's Patient Action Network, specifically in Florida. They have started a work group on mammography accessibility. Their suggestions to the Florida legislature are some of the following: limit non-economic damages such as pain and suffering to not exceed $150,000, change the burden of proof to clear and convincing standard, not just the preponderance of evidence, perhaps exempting interpreting mammographers, which I doubt is going to happen, and also use a panel of radiologists to review the films prior to even initiating a lawsuit. Have not just one expert, but rather a panel of radiologists to look at it. And also to create a multi-agency breast cancer steering committee to promote increased mammography access to the underserved. So this is the work group that's going on in Florida, and hopefully they'll be successful. So thank you very much.